imagine you've crossed a international border. You've got potentially two completely different legal systems with totally different ways to view the law and different entities in the law and the taxpayers, let alone the fact that you have distance potentially between people and property. And the crossing portion of that, in my mind, is either one of those two things. It's either people or it is property. If you have both, it's the most complicated. If you only have one, it's still complicated.
Even things like language are a problem, or concepts that are well-worn law here that may not apply or even be contemplated somewhere else. You could be doing good planning here and it is almost unrecognized elsewhere.
And not very helpful, frankly. I'll give you a quick example of that I run into quite a bit. So I'm physically in Tucson, Arizona, although my practice is international. But just because of where I am geographically, I have a lot of clients who have cross-border issues between the U.S. and Mexico. We in the U.S. use trusts like they're going out of style because trusts are great, they're super handy, but trusts come from old British law. They don't come from anywhere else. It's British. It's not continental Europe, it's British. And by and large, although it's not 100% true because Louisiana is a bit of an outlier, and of course we pick and choose things and add them to our legal system, but by and large, our legal system is based on British law. And so trusts work great here. When you go to Mexico, their legal system is not based on British law. It's based on Spanish law, continental European law, which is more of a quote unquote civil law jurisdiction. The distinction is not important for this podcast, but they don't have trusts. They have a form of trust. They call it a fideicomiso. It's more like a contractual relationship. And it can come up in a number of different circumstances with real estate. It can come up with businesses, but it's not a true trust. And so when you try to go to Mexico with a trust from the US, you get a big stop sign and they say, no, we don't even know what that is. We don't know how to handle it here. You've got to pick some other vehicle. And so even that scenario, we're so close and we do many, many billions of dollars worth of trade just between my state and Mexico. We still can't communicate between our legal systems on that very basic function of a trust in the United States, notwithstanding the fact that they're so common in the US.
And it's amazing too, because, you go to Europe and so on, they have concepts like trusts called foundations. That's also big in the Middle East. But there are distinct differences that don't translate well here. And I guess only Wyoming and New Hampshire technically recognize the concept of a foundation. And for listeners who nerd out on this stuff, I'm not talking about a charitable foundation. This is more of a construct to sort of provide governance over wealth that fits some of the bills of a trust, but not exactly. And I'm sure Asia has a whole bunch of different scenarios as well that, while some things may plant themselves nicely in British foundations, and I don't mean foundation as in the foundation I just talked about, I meant like a building foundation, but that there's just lots of alien terminology or things that mean one thing in one place and something else somewhere else.
And it works the same up and down the list of entities, both on the US side and then on the side of whatever jurisdiction you're dealing with. Because notwithstanding what many Americans might think, the rest of the world is equally smart and sophisticated.
That's right.
And so they have many different legal systems and many different legal entities and structures, and they have their own way of doing it oftentimes, although there's similarities. And understanding how they view their particular entities and then the way the US views those particular entities and vice versa, honestly, is like some days I feel like it's 60 to 70% of my job. It's just trying to figure out how these things match up, if at all, and then try to sort out how do we use them.
Well, and one of the things that's interesting too, I mean, we all have statutes and case law and things like that, but when you've sort of identified the countries that are in play, oftentimes you have to check the treaties that are in force or not in force. And occasionally there can be gaps or commas in places where things weren't drafted, and all of a sudden major sources of wealth and major tax implications or other asset protection can hinge on strange things that may not be part of the typical trust and estates practice.
Yeah, it's very true. And it's nobody's fault, really. It's just it becomes more complex because you're dealing with two different legal systems and sometimes two very different legal systems. And for me, from time to time, clients are a little bit frustrated with that things that maybe in their mind seem very straightforward, they're just not that straightforward. And it's true in even very friendly jurisdictions to us. So we were talking about Canada, for example, not to pick on Canada. I love Canada. I do tons of business with Canadian lawyers and clients. And Canada, notwithstanding how close it is to us, notwithstanding how close the society and the culture is to us, the media is almost the same. You go up there, like all the TV stations are basically American TV stations, but Canadianized. The legal system looks and feels like the US legal system. They are not identical. And their tax rules are not identical to ours. And you have to be really careful, even with that close of a country to us, to not step in landmines. And it's actually really easy to step in landmines if you just don't know what you're doing.
And you can't assume, right? You can't assume that your legal system controls. We'll get into that in just a second, because I think what we were talking about before was the concept of delineating between inbound situations and outbound situations. One of the major decisions, I think, is which law do you want to apply? And a lot of times, sometimes it can and it can't, depending on your facts and circumstances. But that choice of law, that jurisdictional component, is what you're trying to achieve in order to achieve certain goals, whether it's tax or asset protection or any of a whole bunch of other ones. How do you think about that vis-a-vis when a client comes to you with a complex multi-jurisdictional component? Are you thinking about it from a what jurisdiction is going to do best for them and how do I fit the whole thing in? Or is it I've got a fact pattern and there are things that sort of sit out there and I'm not sure I'm going to be able to synthesize this into sort of this omnibus solution?
Oftentimes, it depends on whether you're dealing with inbound versus outbound scenarios. So that might be the right framework to tease this out for you just a bit. So let's, if you start with inbound, and by inbound, I mean foreigners moving to the States or foreigners investing in the States. If they're investing here or they're moving here physically, then at some level, they need American planning. But it might be the case that the American plan is either contained to the US, so it really only governs the US, or it is controlled by a structure that's actually in a different jurisdiction. So you might have an entity that sits in their home jurisdiction. That's the real governing entity. That's the entity that controls the whole piece. And then we try to tie the two pieces together across the border and try to do it in a way that is efficient. I know that all sounds really vague.
Something I've seen in my practice, the concept of there's a choice to be made whether you want to engage in the American system or not. And it sounds like what you're talking about is many times you keep things offshore in a sense as long as possible, or in a jurisdiction that the family is comfortable in as long as possible. And then you siphon off assets into the U.S. as needed so that your exposure to the U.S. system is understood. It's not total. You're not making sort of this binary decision, I'm all US or not US. You're seeing how it goes and limiting your exposure up to the point where when they can make a larger decision later.
That's true. And really doing so strategically and where it makes sense. And there's no one size fits all cookie cutter answer to it, unfortunately. Otherwise, I'd tell you what it was, but it just doesn't exist. But there are a couple of really common issues. So issue number one, if you're talking about somebody who has physically moved here, and sometimes I'm surprised by how easily this is missed, but in my mind, issue number one is they moved here. What if they get sick? So you've got to do all of the basic, easy stuff, the healthcare directives and living wills, and they might have a will here that ties in with their plan in their home jurisdiction. But if they're going to be here, and they're going to be here for a substantial amount of time, I don't want them ending up in the hospital and having to open up a guardianship proceeding for a foreigner in the United States. That is not a great scenario, and it's easily planned around. But that's, for me, like right up the top, you have to do that. That has nothing to do with their money. But then it might be that they are in a situation where they can derive some tax benefits from investing in the U.S. and using some of our structures. So we were talking about trusts. Trusts in the U.S. are great. They're very powerful. You were talking about asset protection. We have great asset protection laws in a lot of jurisdictions. We have great tax laws in a lot of jurisdictions. We have the best economy to invest in for the most part, as far as access to capital. We have great real estate investments. We have great capital markets. So it's a really attractive place to be. Well, it turns out outside of the real estate scenario,